Hello and welcome to this Field Seymour Parks webinar. My name's Ian McRae and I head up the employment law team today, and I'm going to be taking you through some of the changes that are due to employment law in 2020, so you're prepared for what's coming ahead. So let's start by looking at some of the changes to the requirement to give a written statement. So this will apply to new employees or workers, so those that start on or after the 6th of April 2020. Now, you might have already picked up from what I've said, there is a change there already. So previously these statements only had to be given to your employees. That changes. You now need to give them to your workers as well. So if you have casual workers, 0 hours workers, they're going to have a right to a written statement as well if they're starting on or after the 6th of April. The other thing that's changing is you've got to get that statement to them, issue it to them on day one of employment. Previously, you generally had 2 months to get those statements out. You've now got to issue it on day one at the latest. And ideally, you might be looking to send it out to them before they even start. The other things to be aware of, you now need to give additional information. So for example, you need to give additional information about paid leave. So right to paid maternity pay, which is something that's not commonly been in statements previously. And also there's a shift in that more of the information now needs to be in a single statement. So you may recall that the way the law has always stood is there were certain elements that needed to go in a single document, and there were other elements that could be incorporated by reference to maybe other policies or other documents. That's going to change. You now need to get more in your single statement, which is normally obviously contained within an employment contract. Now, the advice in respect to this is review your contracts or your statements if you're using them well in advance. You're ready to issue compliant documents on the 6th of April. And you also might need to look at your working practices as well. In that if you previously haven't sent these out on day one, you're going to need to change that and make sure that you're issuing them that much earlier. Now, the remedies for this, if you don't do this, the employee or worker can go to the tribunal and ask for a declaration as to what their key terms are. And if they're bringing another form of claim, then they can bolt on a failure to provide a written statement, which can be worth up to 2 or 4 weeks' pay. But ultimately, it's something that's relatively simple to get right. You just need to work through the information that needs to be included and avoid those problems down the line. So, next up, holiday pay. I think I seem to talk about this every year, but you'll be pleased to hear that the change this year is relatively straightforward. So again, this is a change that kicks in on the 6th of April 2020. And it impacts on workers who have no normal working hours, or those who do have normal working hours, but their pay varies, either because of the amount done or because maybe they're doing shift work, so they get paid an enhanced rate if they work at night time, for example. And the change is ultimately that the reference period for calculating holiday pay changes from 12 weeks to 52 weeks. So it's an extension to that reference period. And the reason being, the rationale behind it, is that it should prevent employees being penalised if, for example, they take holiday at a quiet time, where, for example, in the previous 12 weeks they hadn't done much work. Actually, their holiday pay is going to be calculated with reference to their earning over that longer 52-week period, which should mean it's a much more realistic sum of pay that they receive. There's also some further guidance that's due out later this year on holiday pay generally, which will certainly be welcomed, as this is an area that still causes lots of problems for employers. Next up, we have some changes that impact upon agency workers. So by way of brief introduction, temporary agency workers generally have a right to pay parity when they've been on an assignment for 12 weeks. So in very simple terms, if they've worked on a particular job for a particular employer for 12 weeks or more, they have a statutory right to be paid the same as a permanent directly employed employee doing the same thing. Now, there has always been an exception to this called the Swedish derogation. And again, what that essentially says is that if the agency was guaranteeing payments to the employee between assignments, then this pay parity requirement wouldn't kick in, so they wouldn't qualify for the pay parity with the directly employed employees. Now that's changing. Again, 6th of April is the key date, not going to be applicable from that date moving forward, and agencies have an obligation to make sure they've issued a statement to those agency workers before the 30th of April confirming that that is the case. Those agency workers are protected from unfair dismissal or being treated less favourably as a result of looking to enforce or rely upon this change in the law. And there's also going to be a requirement on employment agencies to give specified key information to work seekers. It's in no more than 2 pages of A4. There's a particular list of things that need to be included in there, such as the nature of the contract they'll be working under, how they'll be paid, who the employment business is, who the agency are, and they need to make sure that that is issued to them all as well. Now, if you are an agency business, an employment business, you really need to get specific advice on your circumstances. If you're not, but you are a user of agency workers, then you do need to be aware of these changes, because your agency may be knocking on your door looking to renegotiate their terms with you as a result of maybe these increased costs that they'll be facing. Moving on to changes to IR35. Now, I'm not going to dwell on this subject for too long. We have a specific set of webinars that are available either via our website or our YouTube channel. And if you want the accompanying notes to those, please do email me and I'll be happy to send those through. But in very simple terms, we have a change again on the 6th of April, and this is about a shift in the responsibility for operating the IR35 tax rules. And essentially, it will change the responsibility from the personal service company to the end user, the end client, the organisation or the business that is benefiting from the services that the individual via their personal service company are providing. Now, this has already been introduced in the public sector, and these changes will not impact on small employers in the private sector. So if you satisfy 2 of the 3 requirements, so it's annual turnover of not more than 10.2 million, balance sheet total not more than 5.1 million, or you don't have more than 50 employees, 2 of those 3, and you will qualify as a small employer, and these changes will not affect you. In very simple terms, looking at the actions that are required as a user of workers who supply their services via personal service company. Firstly, obviously check, are you exempt from the changes? Are you a small company? If not, do you have individuals who supply their services via a personal service company? You need to do your investigation there and be aware that they may also be an agency in between in that contractual chain. You need to carry out status determinations of those workers, and there's a government online tool for that, or you can use your own analysis. And ultimately that's about determining whether or not there is deemed employment. In short, whether or not they would be an employee for tax purposes were it not for the contractual arrangement that's in place. You then need to communicate those status determinations, and you might need to consider changes to your contracts or the nature of the relationship that you have with your contractors via personal service companies. And also going forward, it would be wise to assess your internal processes to making sure those status determinations are done before any new contracts are entered into. And also, you're probably going to want a lot of greater control over how those self-employed contracts are issued. You need to get your contracts up to date, and remember, you're very short on time for this now because you're meant to be making tax deductions from the 6th of April, so you need to have this all lined up well in advance of that. Parental bereavement leave. So at the time of recording just a couple of days ago, the regulations were laid before Parliament on this. So we have to wait and see whether there's any amendments to those. But in terms of the regulations that have been put before Parliament, these changes will again kick in on the 6th of April. And what it's designed to do is to say that any employee who loses a child under the age of 18 or suffers a stillbirth after 24 weeks of pregnancy will be entitled to 2 weeks leave. They can take that as a single block or as 2 separate weeks, and they can take it at any time within 56 weeks of the death. If they have 26 weeks service and meet certain statutory minimum pay criteria, they will also qualify for statutory parental bereavement pay, which will be at the same rate of statutory paternity pay. So that's the regulations in outline. Need to keep an eye on that just to see if there's any amendments made to those regulations as they pass through the House of Commons, but be aware of that from the 6th of April. Information and consultation. I should stress at the outset of this, I am talking about a set of regulations called the ICE regulations, not the collective consultation you might do where there is a TUPE transfer or where you have a collective redundancy situation. Those types of consultations are unaffected by these changes. But ultimately there has been an ability for employees to request a consultation body, and this applies where you are an employer with 50 plus employees. And they can request that there's a consultation body so you can talk about the prospects of the business, the prospects for employment, any potential changes in terms. And there hasn't been a very good take-up of this right to request this consultation body. And as such, the threshold to request that is now going to lower from 10% to 2% of employees. It is still subject to a minimum of 15 employees though. Something to be aware of if you have 50 plus employees and you receive that type of request in. Final thing that you need to be aware of for 2020 is some changes to termination payments. So currently termination payments over £30,000 are subject to tax, but there are no national insurance contributions required. From the 6th of April, employers' national insurance contributions will be charged on the balance over £30,000. So something to bear in mind if you're an employer, you're paying a settlement payment, you may have a 13.8% employer national insurance contribution due on that balance of over £30,000, which you did not have before. I should stress I'm not talking about notice pay here. The changes that came in last year that made it very difficult to pay notice pay tax-free in any way, they're still in place. This is about payments over and above any form of notice pay. Also got some new rates of pay coming in for national minimum wage and national living wage, so make sure you're compliant with those from the 1st of April. So, usual caveat, this is obviously only a very brief introductory summary to some of the changes that are coming in 2020. Always take your own legal advice. Please do check out the other ways we help you keep up to date with developments, our seminars, our podcasts, our email updates, and our pocket guides that we offer. Details all available on our website. And what I would say is there's a number of key decisions due in 2020 through the courts. For example, the Uber decision on employment status, the MENCAP case, which is due imminently on national minimum wage, and plenty of others as well. And we'll be reporting on those on our email updates throughout the year. Any suggestions for future topics, please do get in touch, and all my details are there.